Good morning, everyone. Good morning, students from UEMP, and welcome to our meeting, to our symposium. It's a big pleasure having you here, guys. Good morning, all the audience. Today, we are going to have a speech by Professor Marieta Safta. Marieta Safta is already known by our students. Professor Marieta Safta have been in UEMP virtually in our meeting at the international debates. So welcome again, Professor Marieta Safta. For those who don't know Professor Marieta Safta, she's professor at Titu Maiorescu University from the University of Bucarest. She's also coordinator of master degree program in European law and also member of the doctoral school within the University of Economic Studies in Bucharest. Among the many activities Professor Marieta Safta developed in her career, she was first assistant magistrate at the Constitutional Court of Romania. She has a lot of studies in constitutional law, European law, and she's a great scholar that we have a great honor to have with us today for listening her lecture on the dialogue between the courts and the future of coexistence in the European Union. So, Professor Marieta, you are a very good friend of us. You are welcome at our university. It's a big pleasure having you here again and our students, and we are super excited to listen your thoughts, to listen your lecture today. Be welcome. The floor is yours, and thanks for visiting us again.
Thank you so much, Professor Jairo Lima. Good morning. Hello, everyone, and good afternoon for me, because as I mentioned before, I'm in Poland right now, and it's afternoon. I'd like to thank you so much for the invitation. It is always a pleasure to be invited by you and to have lecture and meetings with your students. And I hope I'll come in person one day and to meet you and them. But for now, I will use the same way for our presentation. So let me share my screen to be a little bit easy for all of us to understand. Okay. I hope that the screen is shared. Okay, thank you so much. So I chose the topic, the dialogue between courts and the future of coexistence in the European Union. I chose this because, of course, it's an important topic, especially for us here in Europe, but also because it offers me the opportunity to share with you and to discuss with you some ideas of research concerning a project I'm involved in the framework of the Central European Professor Network, the research group, The Future of Coexistence in the European Union. As concerned this academy, Central European Academy, I could say that the aim of the academy is to manage research and training projects that cover especially the Central European countries. This project is focused on the future of European Union and the processes that are taking place inside the European Union. As you all know, that the European Union is a political and economic union consisting of 27 member states, subject of membership, obligation, and rights. And the evolution of the European Union from a regional economic agreement around 1951 to today's intergovernmental supranational organization of 27 countries across the European continent is quite an outstanding one. The autonomy of the European legal order is a heart of the idea that the founding treaties of European Union are not only ordinary international treaties. So EU law is not an ordinary international law. As a result of this transformation since the entry into force of the Lisbon Treaty, because now we discuss about European constitutional order, it could be said the European Union has embarked on the path towards federalism, and at the same time, it is currently an intermediate state where national European processes are from time to time in conflict. That's why I said that I think this meeting is also an opportunity to discuss and learn from you, because Brazil is a federative country, and it would be very interesting to compare a little bit these processes that appears also in the fields that will be presented in this in my lecture. As concerned the statute of European Union, I consider it very interesting a decision of the Constitutional Court of Germany, Federal Constitutional Court, concerning the Lisbon Treaty, the last amendment of the European Union treaties. According to this judgment, accession to European federal state would require the creation of a new constitution. So is not so simple. Require a creation of new constitution in Germany and maybe in the other states of European Union. So, but the Constitutional Court of Germany stated that there is no such act here in the Lisbon Treaty. The European Union continues to constitute a union of law founded on international law, a union which is permanently supported by the intention of the sovereign member state. So the primary responsibility for integration is in the hands of the national constitutional bodies, which act on behalf of the peoples. But with progressive integration, fields of action which are essential for the development of the member state democratic opinion formation must be retained. So the main question in this project is what future for the European Union? As concerns my ideas of research, I have in mind some centripetal forces for the future coexistence in the European Union. And I think that the protection of human rights and finding uniform standards of protection of human rights and the dialogue of the courts in this regard would be such centripetal forces. Here you have some maps to be easier to understand the European Union. So the components, the member states of European Union, and also these member states are members of the Council of Europe. It is important because I will discuss about the protection of the human rights at the national level, at the supranational level, meaning the instruments of European Union, and the international level, meaning regional level, in fact, which means this Council of Europe. Because we have some general instruments of protection of each level. Of course, at the national level, we have constitution. Also, Brazil, Romania, other countries of the world, they have catalogs of human rights in their constitutions. At the level of European Union, it was adopted and it's mandatory, the EU Charter of Fundamental Rights. And at the level of Council of Europe, the most general instruments of protection is the conventions for the protection of human rights. And each level of protection has its own, let's say, guardian. The European Court of Human Rights, if we discuss about the Council of Europe, European Court of Justice, if we discuss about European Union, and at the national level, Constitutional Court of Romania, in the case of Romania. The Constitutional Court of Romania was established according to the Constitution, democratic constitution adopted in 1991. It's a different type of constitutional courts, different type in terms of comparing with Brazil, for example, because we know since our last discussions, there are some important differences. The Constitutional Court of Romania is established according to European model of constitutional review, which means that it's different. It's not a part of the system of the courts of law. A very important effect of this type of the organizations is the effect of the decisions of the Constitutional Court. All the decisions of the Constitutional Courts are erga omnes binding for all the authorities and all the people. In other member states, there are constitutional courts organized according with the same model of European constitutional review. And you have here Austria, Belgium, Bulgaria, etc. We have Supreme Courts, almost similar with the Brazilian system. And we have a country with no constitutional review. It is about Netherlands, wherein constitution is provided that the constitutional court, the courts of law, they have no power to review the constitutionality of the laws. So from this perspective of different catalogs of human rights, different courts of law, it is very important to find the harmony. So the harmonization of the standards of protection of human rights. I quoted here Grain de Burka and Catherine Young because they said that the meaning of human rights has always been susceptible to multiple, sometimes conflicting interpretation in itself. But it's more obvious this difficulty when we discuss about different system of protection. So the main question is, how are those catalogs to be applied to avoid the conflicts and us, people, individuals, obtain the most effective protection possible? It was an important question. So at the regional level here in Europe, the topic was discussed in the most recent conference of the Constitutional Courts hosted in 2021 by the Constitutional Court of the Czech Republic. The topic of that huge conference of the Constitutional Courts was Human Rights and Fundamental Freedoms, the relationship of international, supranational, and national catalogs in the 21st century. I quoted here some of the statements of the President of European Court of Human Rights and the President of the European Court of Justice, because they are very expressive in terms of the relation between national level and international level when it comes about the protection of human rights. For example, the President of European Court of Human Rights at that moment said that they compared this relationship with the sculpture, but a moving sculpture, which consists of an ensemble of balanced parts that can move but are connected with strings or wire. So it's not like a pyramid, a fixed pyramid, it's something mobile. The President Kuhn Lennartz said that an orderly application of fundamental rights does not necessarily entail a separated application of those rights according to their national, supranational, or international origin. Instead, in European legal space, the highest level of protection may be achieved by different layers of protection that interact and complement one another. And you will see later, because I have an example, a very recent example concerning Romania and the recent decision of a ruling of European Court of Human Rights, even very recent in 23 of May, concerning the way in which this different layers of protection function in reality. So the second challenge in this complex picture is the harmonious fashion to apply the sources of law. So the dialogue and the mechanism of dialogue and the framework of dialogue of the courts I mentions, because the coherence and the harmony between courts leads to more profound integration Otherwise, we'll discuss about polarization, and the effect will not be one that leads to that harmony and federal states. How does these instruments and practices function in practice? I brought you here the situation of Romania and the general framework of the relationship between national order and international order regulated in the Romanian constitution, because it looks quite clear from the perspective of the provisions enshrined in the constitution. I said that it looks quite clear because in practice, there are tensions concerning the interpretation and the application of these provisions. But in essence, as concerned the relationship between the instruments of protection of human rights at the national level and the international level, these articles I mentioned in the Constitution stated that human rights treaties to which Romania is a party form part of a constitutional bloc, as in French law, if you heard about this theory of constitutional bloc, with constitutional interpretative value, meaning that the constitutional provisions must be interpreted and apply in accordance with the provisions of international human rights treaties to which Romania is a party, and priority for application in the event of the inconsistency with national laws, unless the constitution or national laws contain more favorable provisions. We will see how, for example, the Constitutional Court of Romania interprets all the rights enshrined in the Romanian constitution in accordance with the provisions of the European Convention of Human Rights and the case law of European Courts of Human Rights. So it's very important now we have a framework. I give you the framework, my national framework, Romanian framework for this relation between national and international order. And now let's see how and which are the ways in which this dialogue between courts function in practice. And I mentioned here some ways, some different ways of dialogue, because it is not about only the case law and the instruments enshrined by different treaties and constitution. I think that also the informal dialogue, the meetings of the judges are also important. So I mentioned here the dialogue through preliminary reference, as concerned the relationship with the European Court of Justice or advisory opinions, or questions of principle relating to the interpretation or application of the rights and freedoms defined in the Convention and the protocols as concern European Court of Human Rights. The dialogue within specific international structures, I mentioned before, for example, that network of the European courts, constitutional courts. But we have also a network at the global level, the World Conference of the Constitutional Courts, and there are also other regional structures. I think that also there are some structures in this regard in the south part of the world, in your region. The dialogue within multilateral, bilateral meetings and other events, and referencing the case law of European Court of Justice, European Court of Human Rights by constitutional courts and national judges. So the first one, preliminary references, these are provided by the Article 267 of the Treaty for the Functioning of the European Union. And this procedure is used when, in the case before a national court, a question of interpretation which is new or of general interest for the uniform application of European law is raised, or where the existing case law does not appear to give the necessary guidance to deal with a new legal situation. So a national court wants to know how to interpret an European law provision. This is, in essence, here in this procedure. And the ruling of European Court of Justice is, after that, generally binding for all the member states of European Union. This is why this is a powerful instrument of dialogue and harmonization of the law at the level of European Union. Maybe the most powerful one. So I gave you here some statistics. There is a link to some documents published on the site of European Court of Justice. And it was noticed a general trend, rising trend in the work of the court. So new references for a preliminary ruling by member states courts and tribunals. So this instrument of cooperation functions very well in practice. For example, in Romania, the direct dialogue with the European Court of Justice was open in the first year of EU membership, because Romania became a member of European Union in 2007. It was a lower court, the Tribunal of Ilfov County, that addressed the first questions for a preliminary ruling. As concerned the Constitutional Court of Romania, also opened the dialogue with European Court of Justice, but later, in 2016, it is about the case Coman and others. This case had as subject matter an exception of unconstitutionality of some provisions of the Civil Code, Romanian Civil Code, having the following wording: marriages between persons of the same sex concluded or contracted abroad either by Romanian citizens or by foreign citizens shall not be recognized in Romania. The legal provisions regarding the free movement on the territory of the Romanian of any citizen belonging to European Union countries in the European Economic Area shall remain applicable. The exception was raised in the context of the Romanian authorities' refusal to grant the right of residence as a family member to the same-sex spouse, an American citizen, of a Romanian citizen. The refusal was grounded by invoking these provisions of the Civil Code. But in this case, the persons involved, they invoked a directive of European Union concerning the free movement. And this directive used the term spouse. And the Constitutional Court of Romania, in order to apply this directive in the constitutional review, wanted to know what does it mean spouse in the sense of European law. So it was not in the competence of the national court to give a definition of this term, because it is regulated in an European act, normative act. That's why the Constitutional Court of Romania sent that preliminary question. And after the European Court of Justice decided and did in this case and stated that the spouse would mean also same-sex marriages, the Constitutional Court of Romania, you have here the judgment of the European Court of Justice. It was said that that text should be interpreted as precluding the competent authorities of the member state of which the Union citizen is a national from refusing to grant that third country national right of residence in the territory of that member state, on the ground that the law of the member state does not recognize marriage between persons of the same sex. So the Constitutional Court found the unconstitutionality of the national provisions. And also it is important to underline, because you'll see what happened after this decision. That's why I mentioned it again, because there are this recent development in this regard. The Constitutional Court of Romania stated in the decision that the relation of the same-sex couple falls within the notion of private life and also family life, according with the Charter of Fundamental Rights and the Convention of Human Rights. So the court upheld the exception of the unconstitutionality and found that the provisions of the Civil Code are constitutional insofar as they permit the granting of the right of residence on the territory of the Romanian state under the conditions laid down in European law to the spouses, citizens of the member states of the European Union, and the citizens of non-member countries, because this was the issue in this case. It was about an American citizen, is not a citizen of one of the member states of European Union, of marriages between persons of the same sex concluded or contracted in the member states of European Union. The marriages was concluded in Belgium in that case. But that decision, okay, a very good decision of European Court of Justice, of Constitutional Court, the dialogue functioned very well, but in fact, this decision was not effective because the authority didn't apply it. And what happened next? You remind that idea of layers of protection that interact and complement one another. Recently, on 21st of May, the European Court of Human Rights issued a ruling in the case of Buhuceanu and Ciobotaru and 20 other families against Romania. After 4 years, after 42 people sued the Romanian state, due to the fact that due to this lack of recognition and legal protection for their families. And the court concluded that Romania has overstepped its margin of appreciation and has failed to comply with this positive obligation to secure the applicant's rights to respect for their private and family life. And you remind that the Constitutional Court of Romania said that it is about the family life. But the authorities didn't take steps in this regard. So the European Court of Human Rights stated that has therefore been a violation of Article 8 of the Convention. So according to this decision, Romania must adopt a legal form of recognition of the same-sex family, because according to the Romanian law, only one form of family union, that heterosexual marriage, is legally recognized. So this is the main way, first way to dialogue between courts. Another way, another type of dialogue, in the framework of that judicial network I mentioned. For example, we have the judicial network of the European Union. It was created on the initiative of the President of the Court of Justice of European Union and the Presidents of the Constitutional and Supreme Courts of the member state in 2017. And you see here the objective. The objective concerned the same harmonization, to share and centralize information and documents relevant to the application, dissemination, and study of European Union law, as interpreted and applied not only by the Court of Justice of European Union, but also by national courts and tribunals, because according with the ruling of this network, the constitutional courts of the member state, they have this obligation to send also a relevant decision to be posted in this framework, relevant decision, of course, concerning the relation between national and European order. There is also in our region this superior court network. It functioned at the level of the Council of Europe and was established in 2015. And the same president of European Court of Human Rights stated that the dialogue between the European Court of Human Rights and the national judicial system is fundamental to the convention system. So superior court network brings together a community of judges. So we don't have national, supranational, international judges. We have a community of judges. All of them are European judges who have a central role to play implementing the principles and values of European conventions. Another way of dialogue in the multilateral, bilateral meetings and other events. And I gave you the example of the Conference of European Constitutional Courts. And I mentioned here a conference in 2014. I know that there are almost 10 years since then, but it's very important the topic of the conference at that moment, because it was about the relationship between courts. In the statement of the conference, it was said that the role of the constitutional courts is no longer restricted to interpretation of national constitutional law in isolation. For a variety of reasons, the impact of European law on constitutional law and the mutual influences between European law and national law have increased in recent years. This applies first and foremost to the field of fundamental rights, but also to other aspects of constitutional law which are determined or influenced by international conventions and the regional level. So see the dialogue between courts and the protection of human rights together as a centripetal force, I would say. So I mentioned, and I will not insist on the most recent conference concerning this of the same conference, the most recent Congress of the same Conference of European Constitutional Courts concerning human rights and fundamental freedoms. There are also many other conferences very important in terms of dialogue between judges. But I chose this conference because of the very specific topic. It was organized in 2021 by Constitutional Court as well. And the topic was EU united in diversity between common constitutional traditions and national identities. I selected this conference because you'll see that concept, national identity, is a very problematic one in terms of the relationship between the states in the European Union. And not only here. I read, and I'll give you as an example of a recent article of a Romanian professor, but he is in the United States of America. He wrote also about this concept of identity with reference with what happened in the United States. And the idea of federal identity, national identity with in relation with the concept of federation. In this conference, it was discussed that EU common legal tradition and how to comply them with the constitutional tradition and national identities of the member states in order to establish a single and harmonious European area of justice. Concluding at the end of the conference, the president of the Constitutional Court of Latvia emphasized the two dimensions revealed in the discussions in the conferences. There are the common values of European Union, the European constitutional tradition of democracy, human dignity, the rule of law, and there is the value and importance of each member state in this area, characterized above all by its national constitutional identity, which the countries of the European Union are committed to safeguarding. The European Court of Justice is prepared to respect this national constitutional identity. However, it is necessary to establish criteria for defining what constitutes a national constitutional identity. We had also a project in the same network concerning the definition, in fact, of the national constitutional identity from the perspective of the each state involved in that project. And I hope that the book will be published soon with the result of our research. As concerned the bilateral meetings, I mentioned the most recent one in Bucarest because it was an important one, I think, because before there were some tensions between Constitutional Court of Romania and the European Court of Justice. And in this meeting, at the end of 2021, it was declared this idea of dialogue, the mutual desire for dialogue. And it was emphasized both the openness of the European Court of Justice and the openness of Constitutional Court of Romania to find a common way to solve issues that are under the European law. In that in the press release, you can find this entirely if you want on the website of the Constitutional Court of Romania. The President of the Court of Justice of European Union stated that the Court of Justice does not rule in a crystal ball. European Union law has the same meaning in all the countries of the European Union. But in order to do so, the Court of Justice needs the contributions of the national constitutional courts, which discover problems relating to the European Union law, possible aspects of the interaction between the European Union law and national law, including the national constitutional law, which refers questions to the Court of Justice for preliminary ruling, and the Court of Justice seeks to interpret the European law in such a way as to harmonize the rich constitutional traditions common to the member states. It was an invitation for the constitutional courts to send preliminary questions, especially when it comes about the national constitutional identity, and I will explain a little bit this thing. And the fourth way of dialogue concern referencing the case law of European Court of Justice, of European Court of Human Rights by national courts and national judges. I explain you the rules provided by the Article 20 of the Romanian Constitution concerning that interpretation in accordance with the conventions of European human rights and the case law of the European Court of Human Rights. That's why this rule is very clear. So the European Court of Human Rights Convention and also the case law of European Court of Human Rights are mentioned in a lot of decisions of the Constitutional Court dealing on fundamental rights and freedoms. I gave you some examples. For example, quality of the legislation. It's a theory which was taken by the Constitutional Court of Romania in all of this decision. The Constitutional Court of Romania interpreted, for example, the principle enshrined in the Romanian Constitution, according to which Romania is a state governed by the rule of law, and observance of the Constitution and its supremacy and the laws shall be mandatory in Romania, in accordance with the relevant case law of European Court of Human Rights. And the Constitutional Court of Romania identified, in essence, some criteria that need to be observed in the lawmaking activity subsumed under the principle of legal certainty. A law that should be clear, precise, predictable, all of this criteria, but in the way described by the European Court of Human Rights. Also, the principle of equal rights was interpreted by the Constitutional Court of Romania in accordance with the rich case law of European Court of Human Rights. I will not insist on this. The principle of non-retroactivity of the law, the right of property. Maybe this is more interesting because it was about the regulation with the purpose to repair the injustices committed during the communist period in Romania, so before democratic period. The legislation on restitution and property abuse taken was challenged many times before the Constitutional Court of Romania, and also these measures were challenged also before the European Court of Human Rights. There is also a pilot decision of the European Court of Human Rights on these issues, Marieta Safta and alții and others, which in that pilot judgment, the European Court of Human Rights required the Romanian state to provide legislation clear and proportional and so on in order to repair these injustices. So, free access to justice and right to a fair trial, all these terms, concepts, reasonable time, fair trial, was interpreted by the Constitutional Court of Romania in accordance with the case law of European Court of Human Rights. The very interpretation of the Constitutional Court of Romania power to review laws and ordinance for the exception of unconstitutionality was influenced by the Article 6 of the Convention concerning the fair trial. And to explain more clearly, before 2011, the Constitutional Court of Romania rejected all the cases when, for example, the law applied in that case was repealed before the moment when the people raised the exception and the moment when the court decided. The court said, okay, it's not enforced this law, so I will not check on the merit, the provisions, the legal provisions. But after 2011, the Constitutional Court of Romania changed this approach in accordance with the interpretation given by the European Court of Human Rights to the Article 6 of the Convention, and stated that it is the case to examine on the merit all these cases when the law is repealed but is applicable in that case based on the principle tempus regit actum. So if the law is applicable in the case, it doesn't count if it's repealed or not repealed. So, as a general characterization, the acceptance of the convention into the national law did not cause significant turbulence or tension, and at this moment the convention is incorporated and embedded in the Romanian domestic legal order. I think it's very important because I'll show you that the more recent tendencies in this regard is the interplay between the European Court of Human Rights and the European Court of Justice. So it's very important that this decision of European Court of Human Rights are somehow embedded into Romanian domestic legal order, because more and more European Court of Human Rights try to protect the European law. And to give this mandatory decision in order to oblige the member states of the convention to respect the European law and the case law of European Court of Justice. As I said, new challenges, the growing interplay between the convention and European Union law reflected at the domestic level, because, of course, when it comes about the harmonization of the human rights, most challenges are determined by mixed reports, which involve all three categories of courts: national, European Court of Human Rights, and European Court of Justice. So here the topic of judicial dialogue is more important, because problems arise for domestic courts, like a constitutional court, or even a court of law of a member state, when they have to combine fundamental rights under European Union law and conventions which set different protection levels. Logical, it would be to find the higher level of protection, but it's not like in this way, because the European Court of Justice decided establish clear rules which make a difference between the harmonization and non-harmonization of the protection level in the European Union framework. So, in the case Meloni, the European Court of Human Rights stated that there are normative conflict between provisions of national constitutional law and European Union law occurs in a situation where the EU legislator has fully harmonized the level of protection of fundamental rights. The compatibility of national measure with such a right is to be examined in the light of European Union law and not according to national constitutional standards. But in other judgment, of the same Court of Justice, Ackerbeck, France, on, where there is no such harmonization, national standards that are higher than those warranted by the EU Charter may be applied. So we have cases when we have to apply, there is a possibility to apply the national standards, and we don't have that fully harmonized level of protection of human rights, and cases when we have to ensure the level of the protection stated at the, by the European Court of Justice when we have this full harmonization. So it's not so simple. As for the viewpoint of European Court of Human Rights, I gave you here some recent cases. Because I would like to emphasize that relationship. I mentioned it before, that relationship between European Court of Human Rights and European Court of Justice, meaning the case law in which European Court of Human Rights tries to determine the states to respect the European Union law and the European Union Court of Justice case law. And I gave you these cases concerning Romania, Spasov versus Romania and Moraru versus Romania. For example, in Moraru versus Romania, the European Court of Human Rights found that the Romanian courts failed to meaningfully engage with the relevant case law of European Court of Justice, which the applicant had invoked before them. So the applicant invoked a decision of the European Court of Justice, and the Romanian courts failed to meaningfully engage. What it's important, what the definition of this meaningfully engage in the future. Maybe we'll see also a definition. I think in itself, this development is a positive one, leading to a convergence of the standards applicable to the protection of fundamental rights, to have the same language of fundamental rights applied at the level of Europe, in fact, because we discuss by the European Union, but also by the Council of Europe. But it would be important also to have a definition on criteria for this meaningfully engage, for this kind of term of evaluation of the national courts of law. I discussed about somehow harmony between courts, but sometimes there are also tensions between courts within the European Union. Usually there are famous, I think, this kind of tensions. There is a case of German Constitutional Court, Polish Tribunal, Hungarian Constitutional Court, and even the Constitutional Court of Romania was not exempt from these 10 stages. We had a recent development in this regard in 2021. It concerns the independence of the judges. There are a lot of cases of the Romanian judges from the courts of law, a lot of preliminary questions sent to European Court of Justice concerning their independence, their disciplinary procedure against them in the situation in which they not follow, for example, the decision of the Constitutional Court, and also the response of the Constitutional Court in this regard. In fact, it's only one decision pronounced in 2021. I would characterize it as a typical one, because we didn't have such tensions before. We don't have time to develop more this topic, but with what is important what there are importance, which are the problems. In fact, the problems concern the relationship between national and European law order, because it was discussed the idea of the supremacy of European Union order or supremacy of the national constitutions, or primacy of the European law order face to supremacy of the Constitution. And another concept, another big discussions concern the constitutional or national identity. It would be important to know that the concept in itself national identity is enshrined in the European Treaty. In Article 4 of European Union Treaty, the Union shall respect the equality of the member states before the treaty, as well as their national identities. So the question is, who is entitled to establish what national identity means? Because the European Court of Justice said, okay, I have to establish what means because it's in the treaty. But in the same time, the constitutional courts of the member states, they said, okay, but it's about constitution. It's about the constitutional order, our constitutional identity. I gave you here that article I mentioned at the beginning of our meeting, wrote by Professor Vlad Perju, Identity, Federalism in Europe and the United States. It's a very interesting one. I quoted some paragraphs here. He wisely said that both national and supranational European courts have recognized identity, not only as a political safeguard of Europe's admittedly sui generis community in the process of progressive integration, but also, and importantly, as a doctrine that constitutionalizes national identity on both national and European levels. His highly adapted doctrine has been used both defensively as a closure mechanism that shields national states from deeper supranational integration, as well as offensively as a sword against the authority of the European Union. If you are interested, you can find these decisions of the courts I mentioned, where the identity, the constitutional identity, is a kind of the shield. So it's a limit for the European integration, in fact. So in this recent decision pronounced in 2021, Romania, the Constitutional Court of Romania, established for the first time what does it mean Romanian constitutional identity. And the court referred to the provisions of the Article 152 of the Constitution of Romania. We discussed before in our meeting this eternity clause, because I know that you are interested in the amendment of the Constitution and limits of the amendment of the Constitution. But we have also this recent development concerning the meaning of the national identity. So all these values enshrined there in the Article 152 compose the constitutional identity. But the court refers to those kinds of constitutional values and principles as representing the fundamental identity core of the Romanian Constitution. So there is an identity core, there is a wider content of Romanian constitutional identity. And also the Constitutional Court of Romania considered that it's in the power of the Constitutional Court of Romania to find the elements of the constitutional identity. Till that moment, the Constitutional Court of Romania referred to the constitutional identity, invoking also the examples of the German constitutional courts usually, but we didn't have a definition or a content of the European, of the constitutional identity. After the decision pronounced by the Constitutional Court of Romania in 2021, the judges from the courts of law sent new preliminary questions to the European Court of Justice. And I quoted here that the reasonings from this decision pronounced by the European Court of Justice in the case RS, because there the European Court of Justice established itself who is entitled to describe the national constitutional identity. The European Court of Justice established that if a constitutional court of a member state considered that the provisions of secondary European law, as interpreted by the court, infringes the obligation to respect the national identity of the member state, that constitutional court must stay the proceedings and make a reference to the court for a preliminary ruling under Article 267 of the treaty. So I think that it's a perspective on the same dialogue. because a national constitutional court finding something that it looks like an element of national constitutional identity has to ask European Court of Justice and to explain why that element specifically is this element is an element of constitutional identity, and the final words belongs to the European Court of Justice, because it's in its competence the interpretation and application of the European Union law. So I think that the use of the concept of constitutional or national identity creates, through constitutional dialogue, a loyal constitutional dialogue, a bridge, and maybe to provide a key to coexistence and development in European Union order. So I'll pass to the conclusions. I think that these few examples of some tensions or some ways in which the layers of the protection function in practice proves that we need for strengthening the dialogue in European Union law. And here I quoted a paragraph from that article of Professor Vlad Perju concerning the concept of identity federalism. And that because Professor Jairo Lima, I'd like to ask you also about the experience in of your country, of Brazil. There are discussions concerning the identity in Brazil, the identity of the states as a member of the federation. It would be very interesting. That is why I mentioned this concept. However, the European Union remains in the position to create permanent tensions, so it's important to transfer these tensions from the formal constitutional conflict to of the competition with the purpose to achieve the objective of a joint project. And from this perspective, I think it's relevant also very recent decision ruling of the European Court of Justice, because in that ruling, in an action introduced by Hungary, supported by the Republic of Poland, it was the first time when the European Court of Justice gave a definition of the own identity of the European Union. The European Court of Justice stated that the values contained in Article 2 of the treaty have been identified and are shared by the member state, and they define the very identity of the European Union as a common legal order. So right now we have identity of the member states and identity of this supranational entity, European Union. I think that the dialogue of the judges is more important in this very complicated and turbulent picture, I would say. Maybe we should rethink the legal framework in order to obtain more harmony. Maybe the instruments we have in this moment are not sufficient for ensure this dialogue to be effective and to lead to a more integrated European space. That's why I would be happy to hear about the experience also of your country, and thank you so much to you and to audience for the attention. Thank you so much.
Thank you so much, Professor Marieta. Brilliant as usual. Your speech was very clear about the situation of dialogue between courts in European Union, and it was very interesting to see how many challenges you scholars do you have in Europe to try to create, to explain, or to understand these changes in terms of states, in terms of judicial power, in terms of legislation, according to the dialogue between national and supranational. So that's the reason, I guess, why European scholars, you are very concerned about European law and so on. That's the reason, because the challenges are huge.
Yes, because for a judge, it's very complicated to apply all these instruments of protection, and it's his responsibility in each cases he has. It's his responsibility to apply also the national laws and also these European laws, which are mandatory, some of them. So it's important to know the rules and to be very clear in this regard, also for the both for the judges and or for the citizens. For us, it's very important.
One comment I would like to make, something that came to my mind when you were talking, you were explaining to us how would be this interaction between the interpretation of the legislation. Okay, but do you see the same movement of trying to harmonization in the changes of the legislations between national and supranational? Do you see the same movement?
Yes, it is, because there are more and more initiatives to harmonize different areas of laws. Because according to the European treaties, we have specific competencies of European Union, specific competencies of the member states, and shared competencies, exclusive and shared. So the legislation should follow this repartition of the competencies. And sometimes the borders are not very clear. And it is also important, the role of European Court of Justice, because the interpretation of the European Court of Justice of the legislation, even the legislation is not fully harmonized, this interpretation leads to the common standards. European Court of Justice is a very important actor of this harmonization. And this instrument of preliminary ruling is a very powerful one, because the decisions being mandatory for all the states, after that, the legislation will follow these rules. And this is the way in which, for example, an area of law which is very, very close to the idea of sovereignty, like criminal law, become, I think, more and more harmonized through this interpretation of the European Court of Justice. Because when it comes about the interest of European Union, so European Court of Justice is competent. So the national court, they have to send preliminary questions in order to find the meaning of legal acts applicable in this area, also the criminal law. Mm-hmm. So even the criminal law become more and more harmonized at the level of the members of European Union. So we have the direct action of the legislator in the specific fields, the duties enshrined in our constitution to be loyal to this construction, because it was our will to have this construction and to be members and to follow the rules we established together. And also we have the action, which is very important, of the European Court of Justice, of the national courts, and this continuous dialogue between the courts.
Mm-hmm. Moving back to the question of the interpretation of the judges, Marieta, I guess that in Europe, there are many different ways to become a judge, depending on the country, on the member state. So do you in Europe, do you have some sort of common standards or common contents in the universities to prepare the future judges to this kind of harmonization?
Yes, I think that also here it is the same tendency to find the common standards. As I said, it is mentioned in the rulings of the European Court of Justice and so on that the national judges are European judges. So it's important to follow the same rules. Usually the independence of the judges and the standards of the independence of the judges represents a kind of core of this whole legislative movements at the level of European Union. And I think that this kind of harmonization in terms of regulation of the position of the judges and the independence of the judges will continue in this regard. So it's really an important area for harmonization, this topic, mainly the independence of the judges.
Yeah.
So the standards to ensure the independence.
Depending on the country, on the member states, they have some different levels of independence, and this is important to create a better culture in terms of protection of human rights, mainly when the state is the violator and so on. But there are two questions here from the students about the constitutional identity, because to me, constitutional identity was the hot topic of your speech. One of them asked about if you as a constitutional scholar in Europe, if you see any sort of threat to constitutional identities in Romania or in other country in the European Union. Do you see if there is nowadays a movement from the European Court of Human Rights, from the European Court of Justice, a movement or an example of threat to constitutional identities?
Thank you so much for this. It's a very wise question, because I'd like to thank you so much, because the person who asked me noticed that this topic counts when there are problems, isn't it? If we have problems and threats, okay, we'll provide arguments to protect something like constitutional identity. So, but the question is great, but the answer is not so simple, because we don't know what does it mean, constitutional identity. As I mentioned, the constitutional courts tried to explain somehow what does it mean, constitutional identity. We have a more recent case, for example, of the European Court of Justice, who stated that, for example, the language is a matter of identity. And in that case, I think there were some threats, but at the level of that state, in order to impose another language for teaching in the school. I think that was the case. But I don't know other threats to specific elements that were characterized as constitutional identity. If you will compare this is my idea. If you compare what European Court of Justice stated that are elements of identity of European Union, and for example, the core identity of our constitution, we will find that a lot of common elements, because it was in fact about the exigence of the rule of law. So we have to find the same standards. We have a mechanism of rule of law applicable at the level of European Union to all states of European Union. I'm not sure, I don't see at this moment this kind of threats, Maybe it's that's why, as also Professor Vlad Sperjus said there in that article, the constitutional courts used mainly the German constitutional court because she developed this idea of constitutional identity more than other courts. Maybe it's a kind of mechanism of prevention. Okay, this is our constitutional identity, so we'll examine if something happened and threat this constitutional identity.
But
at this moment,
But in your opinion, Marieta, do you agree that the competence to acknowledge the national identity is of the national courts, or not necessarily the competence to say what's the national identity? Do you think
No, I think that in order to have to not have tensions in this regard, and also taking into account both the competence of the national courts and European Court of Justice, I think that it's a shared task. They have to work together in order to define these elements of constitutional identity. It's a kind of reasoning as mentioned by the Court of Justice, European Court of Justice in the case RS. I think that the Constitutional Court should have a dialogue with European Court of Justice, have an argumentation, and in this way we'll find together the same content of the European identity. I see that it's I'm kind of utopic now to see such an harmony, but this is my idea. I'll do like this if I'll be a judge. So.
And that's brilliant. There's another question from our students still about the constitutional identity. He asks about you have shown us about some kind of dialogue between judges and the judges, like the community of judges, seminars, conferences, and so on, some sort of trying to dialogue between them to find some sort of harmonization. But in terms of to have more influence from the society, do you see if the national courts or the European courts, they have some kind of communication with the society, with the civil society, in order to have more elements in terms to understand what's constitutional identity, for example? Do you see if there is this opening from the courts to the society, or they are still talking just between them?
It's an amazing question. You know, it's somehow related with my next research for that World Congress in New York, because there I would like to search and to find an answer and to advise somehow as a scholar the court to be more transparent and to discuss and to be open also with the society, with the people. Indeed, it's not enough a dialogue between judges. Recently, I participated in the project. I was invited to say a few words in a project concerning the constitutional justice. It was in Bratislava, that meeting last month. And the topic was the role of the judges as an educators. You know, the judges should be an educators as well, in various ways. So this discussion and this openness to the civil society and the transparency, it's a way to ensure this role. And maybe they will learn also from this experience in order to find a way to conciliate somehow these conflicts at the national international level. So it is indeed a very, very, very good topic of of research and of thinking. Yes, thank you so much.
Yes, we ask it because we have a student in our PhD who is trying to research about this judicial communications, the way that courts they interact with the society, using, for example, the case of the Constitutional Court, the Supreme Court in Brazil, which has a lot of mechanisms of communication with the society, social networks, and so on. But he's trying to understand if this kind of communication, if it represents a real dialogue, or just to send information, not to hear from the society. And this is, I think that's the second challenge in terms of communication, not just to say, but also to hear from the society. But it's amazing to know that you are also worried about these questions. I guess that we have a lot of things to share in this topic. Yeah. And just to finish, Professor Marieta, in terms, you asked me about the Brazilian federal system. Okay. I will be trying to be very short in this question, because there are a lot of problems related to federalism. But to understand the Brazilian federal system, we have to understand that our federalism is quite different from the US federalism. Why is that? Because in the US, the state members, they are very powerful in terms of competences, in terms of freedoms, in terms of regulations. In Brazil, it's the opposite. The state members, they are not so strong. They are weaker than the national union. So the main questions about legislation, about rights, they are all competence of the union. The competences that remain with the state members are some sort of taxes competences. Competence in terms of taxes, not competence in terms of general rights, in terms of electoral law, for example. All this kind of topics, procedures, civil procedures, electoral law, human rights, they are all competence of the union. So even though Brazil is a huge country with very different states, with different cultures, the regulations about the cultures, about the social life, they are not competence of the state members. So this is the main reason, I guess, that we don't have this kind of conflict. The main conflict between the union and the state members are conflicts about tax law. That's the main conflict between the federal system in Brazil. However, we have already another problem in our federal system, because we have another level in our federal system, because we have municipalities. Municipalities in Brazil, they are part of the federal system, so they also have their proper competences, which are different from the state and different from the union. So we have three levels of competences, and the weaker of them in terms of constitutional competence is the state member. The municipalities, they have some sort of a particular private interest in the interest of the place, the interest of the municipality. They can rule on this topic. And the general interest, they are ruled by the national union. So it remains with the state members almost nothing in terms of the legislation. This is some sort of the reason we don't have cultural and social conflicts between the state members and the union. This is a general, there's some peculiarities, but it's the general panorama.
Thank you so much. So it's a great idea to compare different system of federalism in order to find common points or, I don't know, perspective for the evolution of the European Union. So not the federalism in itself, but different types and different solutions adopted at the level of the states. So it's an important
other topic that we can talk later in other opportunity is the relationship between state courts and federal courts and national courts, because in comparing your perspective, you are trying to say the relationship between national courts and supranational courts. Here in Brazil, we have some sort of relationship between the state courts and the union courts. So maybe this relationship could be interesting to compare with your problem, with your research. But I guess we don't have time enough for that now, but we can chat it later and we can develop common research in that topic.
Okay, so many great ideas. Thank you so much. Also with the questions gave me idea as well. Thank you so much.
Yes, I would like to thank you again, Professor Marieta. And just to mention, I forgot to mention at the beginning of our meeting, I would like to thank again, and for the students who don't know, the students of the Titu Maiorescu University, they have been our students at UEMP last year, virtual students. We received them as students in the virtual mobility program. Thanks to Professor Marieta for helping this activity. I hope that they enjoy the activity to know a little bit more about the things in Brazil. It was a great experience to me and a great experience for our university as well, to have the Romanian student here in Brazil. That was so interesting to have this connection, Professor Marieta.
Thank you so much. Thank you so much. It was thank you to you for this idea, the brilliant idea, and the students enjoyed so much this experience in itself, and also your presence and your way to explain them and make this topic very interesting. And in fact, I invited them to present their colleagues the experience, and the other students are very interested also to develop this kind of project. So thank you very much. It was a great experience, mainly in that times when there was a difficult time, you remember, with the pandemic and so on, and finding some solutions to communicate.
Now they know a little bit more of Brazil than football and carnival.
For sure. Yes.
So thank you one more time, Marieta, for having a time for us. I know that you are super busy in your activity in Poland. I thank you so much for sharing with us your time. You know that our university is always open to you, and we are super also excited to have you here in presence. I hope to find you in presence in Europe this year. I hope that. Yes. And we keep in touch. Your presence here was very important for our seminar, for our international congress today. Remembering the Romanian students, mulțumesc.
Yes. Thank you so much. Mulțumesc. Have a nice day, and see you in Romania soon.
Bye-bye. Thank you so much. Thank you for the students, for the audience today.
Thank you to all.